everyone, I'm Alina Santana, and today I want to talk to you about immigration court and how it works. I'm an immigration attorney and spend a lot of time in immigration court, and there's a big difference between a master hearing and an individual hearing, and it's important that you know the difference if you are currently in immigration court proceedings. A master hearing is a preliminary hearing. It's the first hearing you go to. Sometimes there's a second or third one, but it's definitely the first one you go to. And it's where you talk about with the judge why you should remain in the United States. And I don't mean talk like a testimony. I mean, there's going to be a charging document. It's called the NTA, the Notice to Appear. And at some point, you should have received that document, either in the mail or in person if you apply for an immigration benefit. That document says all the reasons that immigration thinks that you are deportable, and your first hearing is where you get to address those charges. It's very important that you get an immigration attorney to do this with you. Can you do it alone? Technically, yes, but there's a lot of legalese and jargon, and it's very confusing and hard to explain when you represent yourself. So I would highly recommend that anyone facing immigration court get an attorney to help them with their case. Your master hearing is also where you may present your application. In other words, whatever you're going to be applying for, whether it be asylum, a marriage-based case, anything that you're going to argue to the judge as your affirmative defense for why you should not be deported, gets presented at a master hearing. If the judge decides not to give you a second master hearing, he may instead give you a date called a call-up date, where you have to submit your application by that date with the immigration court, and you can do that in the mail or at their window. The second type of hearing in immigration court is called an individual hearing. An individual hearing is more what you think of when you think of a trial. It's the opportunity where you truly get to give your testimony about why you should get to stay in the United States and what you qualify for. Oftentimes, we also have witnesses for those hearings. Sometimes they're family, sometimes they're experts. It really depends on what it is that you're arguing in court. But that hearing is just a hearing for you. The master calendar hearings, which are the first ones I explained, there will be a lot of people at. Lots of different people will go up and down and talk to the judge and talk to the DHS attorney, and it's relatively quick while you're there. The individual hearing, that second and last hearing that I'm talking about now, is completely different. It really is a courtroom for you. You will have an interpreter there. There will be a DHS attorney arguing the government's position on why you should be deported, and there will be a judge, as well as yourself, your witnesses, and hopefully your immigration attorney to discuss with the judge why or why don't you deserve to stay in the United States. This is the last step in the process, and it's really where you get to hear from the judge whether you've won or you've lost your case, and whether or not you get to remain in the country. If for some reason the judge does not grant you your case, you always can appeal, but you only have 30 days to appeal. So it's very important that you do so if you do decide you want to fight to the very end. If you or someone you know is facing immigration court and finds it as confusing as most of my clients do, please give us a call for a consultation so we can talk about what you qualify for and what you don't and figure out how we can best defend you in immigration court. Our office number is 305-916-4800, and we'd love to represent you. Have a wonderful day.